Our judges have not been involved in partisan politics or all that goes with it. They have, I think, carried out their responsibilities in the highest tradition of the judiciary in this country. We have been fortunate. They work every day to uphold the rights of ordinary Iowans, have decided tens of thousands of cases at the trial level and at the appellate level, and I think have done a remarkably good job. And I am concerned today at the notion that there will be an organized effort to upset this tradition on the basis of a single decision that a segment of our population in Iowa is unhappy about. I think this is unfortunate. It's an effort to throw the system back into partisan politics. It is a challenge to the tradition of judges respecting the rights of individuals and enforcing the law, as is the responsibility of the judiciary as an equal branch in our three departments of government. So I am here because of my concern about this effort. I'm here as an individual who has spent time in the judiciary and has spent time in our courts all over this state and have spent my entire professional life working in the system that I think we should all be concerned about preserving at this time. I'm happy to take questions.
Are you aware of any group that's been discussing organizing a group to support retention? I'm not aware of anything specifically. I do know that the Iowa State Bar Association has a committee, which I think Dwight James is chairman, which has as one of its roles defending the judiciary, or at least maintaining communications on behalf of the judiciary when there are public issues that it doesn't appear it would be appropriate for the judges themselves to respond to.
Is there something different we should be doing in appointing and retaining judges?
I sure don't think so. We have a wonderful system. I have met judges in my career all over the country. I used to go to a lot of judicial conferences when I was in the judiciary and have met judges, including one experience. I remember particularly a judge from Georgia who was in an elected system who had made an unpopular decision, and he started talking to me about their system. And he started crying. He said, "I'm going to lose my job," he said, "at this next election, because I made a decision that upset a murder conviction." And he was crying, very sad, but he was determined that he had made a correct decision. It was just that it was devastating on him personally that he would be subjected to the public retribution for having made an unpopular decision. We don't have that in Iowa. We haven't had it in Iowa. We shouldn't have it in Iowa.
What should these three justices do? Should they stay above the fray, or should they organize a campaign committee and launch their own retention efforts?
They could, but I suspect that they won't, because I think that we who are part of the system in Iowa, including non-lawyers who have created this system through the 1962 constitutional amendment, will ourselves organize to do whatever is necessary to retain it. So I don't believe that the judges themselves are going to need to get personally involved. And I think they probably will feel that they shouldn't.
Why is that?
Well, the very reasons that I've stated for the judges being out of partisanship and political battles. If you look at the decisions of the court, most of them are pretty boring in terms of public interest. but they are important to the people involved. There are two decisions that were filed this morning by our court. They filed them customarily on Fridays, and I read the two decisions that were filed today. One was a workers' comp case involving a worker in Dubuque who had suffered a leg injury that required amputation of his lower limb. And the issue was really his entitlement, the extent of his entitlement to workers' compensation benefits. That case would not be interesting to most people, but it's certainly important to the individual involved. And the court wrote a well-reasoned 14 or 15-page decision analyzing the legal issues involved, interpreting the statutes, and arriving at what I think most of us will believe is a fair decision. The other decision the court filed today was an attorney disciplinary case. A lot of folks don't realize that lawyers are subject to regulation by the Iowa Supreme Court as an agency of government, as officers of the court. And this case involved correcting the conduct of a lawyer and providing for a sanction involving suspension of his license for having not adequately served his clients. These are typical of the kinds of decisions that are made by our courts every day on behalf of the public in Iowa and all of us, the citizens in this state. I think that the business of the court needs to be better understood by folks particularly who get emotional and get upset over individual decisions. There are tens of thousands of decisions that are made by our judges every day that don't have the visibility of the decision that's caused this upset among a segment of our people. I think these folks don't understand the kinds of things that are taught in middle school civics about the separation of powers and the supremacy clause under our constitutions. And that is that when the Constitution is to be interpreted and applied, it is the role of the courts to do it. And when they do it, the other two branches do not have a right to infringe on the judiciary's prerogative under the constitutions. That's true at the federal level, and it's true at the state level.
They say that balance has been upset by judges who have become activists on issues and are attempting to legislate from the bench.
So that is always said by somebody that disagrees with a decision that has a particular impact that the individual doesn't like. There is no such thing as an activist judge in the sense of that I'm aware of, in the sense of a judge who does not believe that he or she is carrying out his or her responsibility. And it's really just common knowledge, I think, among members of the bar and the judiciary that the role of the courts is to interpret and to assure that the statutes and the Constitution are enforced. And it's not activist to interpret the Equal Protection Clause of the federal and state constitutions to a situation following precedent. And those folks that have read the decision that is in controversy here will see that it is a lengthy decision which cites numerous cases in Iowa and from the federal courts that our court believed supported its decision. They were not freewheeling. Our court believed that it was applying precedent to the case before it, and that's what courts do. We have a system of precedent, and this is our common law system. It is our constitutional system. It's the system that every state has and that our federal system has.
Have you talked with any of the three justices that are up for retention bids this fall?
No, I have not.
What would be the effect if they succeed?
It would be discouraging. They would be replaced, and we would have probably people that this group might be just as unhappy about, because my anticipation would be that if we get the quality of judges that we have had traditionally in Iowa, we will get judges of the quality of the 3 judges who are being challenged currently. I don't think this campaign can or should succeed, and I don't understand the motivation for it. At least I don't understand the goal, except perhaps vengeance over one decision out of tens of thousands of decisions that have been made by the judges of our appellate courts.
Would this have a chilling effect on the judges who were still on the bench if these 3 were defeated?
I don't think so. I know our judges, and I believe the judges will have the same sense of responsibility and integrity that they do now, and they're not going to be chilled by this sort of emotional bombast.
Governor Branstad has staked out a position that he thinks the current selection system is flawed, and that Iowa should go more to the federal model where the president has a free hand in selecting a Supreme Court nominee, and then the Senate would confirm that nominee.
I disagree with the former governor on that issue. I think it would be a distinct step backward, and it would be out of synchronization with what every legal expert in this country on the judiciary and on our system of selection and retention of judges, who at least is widely respected in the field. It's widely out of synchronization with the views of people that advocate for the methods of selection. We have what's called the modified Missouri plan system of retention. It's not, as Mr. Vander Plaats said, a system where the Bar Association names the candidates for judiciary. It is a system where we have commissions that are comprised of laypersons, that's non-lawyers as well as lawyers, who meet and determine who the nominees would be without regard to political affiliation. And I will say this, I served on the Iowa Supreme Court for 14 years with a number of judges who came from both political parties in terms of their affiliation and registrations. And I never once in that 14 years heard any discussion that would suggest or intimate in any way that partisan politics had any impact on the point of view of the particular judge. In fact, you would not know if you didn't independently have information about what the registration politically was of that judge. And it was a group of people during my period on the court that I developed tremendous respect and affection for, who always acted professionally and with integrity and with the interests of the people of Iowa and their responsibilities always foremost. So it's astounding to me that anyone would suggest that these people were off on a hike of their own, some sort of a frolic, and decided that they wanted to make some law, and so one day did so, instead of having had a case that was carefully submitted with all points of view being heard, including amicus curiae briefs from every interest group that wanted to file a brief with the court, and then with the attention to precedent, as is reflected in the lengthy decision that was filed, make a decision that the court believed was consistent with the law and the constitutions, both federally and state. It's surprising, it's disappointing, and it's astounding that this would give rise to the kind of campaign that we're told is going to be conducted. Who are these people? Who's going to fund this campaign against our judiciary? I hope they will reveal who it is that's behind this campaign. I hope Mr. Vander Plaats will provide some transparency and make clear what the agenda really is here, what the objective is.
Anything else, guys? Thank you all very much.
Thank you.
Thank you.
Thank you.